Today is November 7th. I'm Cindy Allen, CEO of Business Multiplier, a global consultancy services. Welcome to Simply Trade, Cindy's version, where I base an international trade update on a Taylor Swift song. I am coming to you today from Detroit, so hopefully I can get back home to Memphis over the weekend. We'll see. We'll talk about that in a minute. This podcast is brought to you in association with the Global Trading Center. Today's song is Endgame. It is off of Taylor's Reputation, which was released in 2017. And that's due to the IEEPA court case, which I'm going to get into later. But first, what happened in international trade this week? Well, first of all, I do want to express my deep sympathy to my Express family at UPS and the families that were involved in the airplane crash earlier this week. Huge loss. And no matter when this happens, no matter what company you work for, your sympathy goes out to your fellow industry representatives. So my deepest sympathy to the UPSers and the families that were affected. On Monday, the heavy-duty truck and bus tariffs take effect next Monday on November 10th. The truck tariffs are 25%. The bus are 10%. There are some carve-outs for emergency vehicles. The UK will be kept at 10% according to the trade deal that was signed. So the automotive has extended to the heavy truck. So that's also good. The EU as well will be limited at 15% and Japan at 15% as well. So those limitations have kept. So that's good. It's good for us in international trade because it has some consistency through it. The executive order actually reducing the China IEEPA fentanyl to 10% also was released, and it takes effect again on Monday, November 10th. So that's good news for those of us who are importing from China. We'll see that. We are now officially in the longest federal shutdown in the history of the government. We are over a month now, and we are starting to see some impacts of that. Specifically, we have seen announced over the past couple of days, as I was sitting in an airport on the way to Detroit, we were watching live the announcement from the Federal Aviation Administration that they have directed the 10% reduction of flights from 40 major airports. And that is a huge impact. That covers, according to the AP reported, would cover 1,800 flights and in excess of 268,000 seats on the planes. So we do expect some impacts to both cargo and individuals traveling in the United States. And I recently, as of this morning, saw another report that they're going to increase that to 15% over the course of the next few weeks if the shutdown does not end. This is a result of safety. The Department of Transportation was very clear that this is due to some concerns that there are not enough air traffic controllers, and safety is number one, and that is the reason they are reducing this. Many airlines have proactively rebooked passengers and are proactively rebooking cargo and connecting with those individuals who are booking cargo in airline seats. So if they had 9 flights, they're reducing that to 7. If they had, in excess of 15, it doesn't seem to be completely eliminating options for flights between cities, but we do expect that to continue to impact how people are traveling in the United States. So as I said, I'm sitting here in Detroit and hoping my flight does not get canceled on Sunday. Otherwise, we might see some additional passengers on the ground or some cargo being diverted to truck or other modes of transportation. So we'll see what happens. That's early in the process. Let's get to Endgame. And the lyrics of Endgame I thought were really applicable to the IEEPA court case that happened just a few days ago on Wednesday, November 5th. Her lyrics are, I want to be your endgame. So that's all of us who are like, we want to just know if these IEEPA tariffs are going to go away. Further in that song, she talks about she has a big reputation, which is where the name of the album actually came from. But big reputation, you and me, we got big reputations. And you heard about me. I got some big enemies. And as well, she says, you and me, we'd be a big conversation. The big reputations, I think, in this case, are the government who instituted the IEEPA tariffs and the trade who are actually opposing those tariffs. Wednesday, that big conversation actually happened. The government and trade went before the Supreme Court in what was seen as a very long hearing for the Supreme Court. It lasted in excess of 2.5 hours. Usually you see 45 minutes of arguments. In this case, they actually budgeted 80 minutes, but it still exceeded that. So lots of conversation, lots of questioning by the justices. We did see questions split along party lines. For the most part, those justices that were actually appointed by conservatives asked questions that seemed to support the government position. And those justices who seemed to lean on the more liberal side asked a lot of questions that seemed to support the trade's position and allowed them to articulate both sides of the argument. Those in the middle, even though they were appointed by liberal or conservative judges, but are considered to be really in the middle justices, they asked some very pointed and detailed questions. It was very interesting to hear. I was surprised, actually, that there wasn't more talk of what the definition of an emergency is, because IEEPA does stand for the Economic Emergency Act. So the definition of emergency seems to be central to that authority. But the justices were quick to point out that that was articulated in the briefs that were submitted to the court already, and there wasn't a lot of questioning around the definition of emergency. There was a few mentions by both sides of an emergency and why they thought this was an emergency or thought it wasn't an emergency, but that was very brief in the conversation. So that kind of surprised me. It was more about the actual authorities that IEEPA grants. The specific language that the IEEPA Act refers to says it allows the president to regulate imports. So what does regulate mean and what does regulate imports mean? There was a lot of discussion around that. There were points made that regulating imports really means tariffs, and that it is implied that that authority is vested in the IEEPA by indicating that the president has the authority to regulate imports. How else could you regulate imports? So that has an implied meaning. That was what the government argued. The trade argued that regulating imports could take other forms, such as quotas, such as visas, such as other limitations that actually are not tied to tariffs. And they specifically discuss the fact that language in Section 338, which has not yet been used, Section 122, which also has not yet been used, and Section 232 actually specifically lists that the president has the authority to assess tariffs in an amount after an investigation under 232 with a time limitation. Section 338 and Section 122 are both very much more specific on the amount of tariffs that can be assigned and the days in length that it can be assigned. It's hard after listening to the 2.5 hours twice now. I went through the live hearing and I listened to it again. I'm having a hard time making a prediction what's going to happen. I think it could go either way. I think the briefs that we saw, the filings that we saw actually, leaned more toward the trade that these are going to be unlawful. But after hearing the oral arguments, I'm not quite sure. I think it's a 50-50 call right now. I don't know which way this is going to go, and I'm not ready to hang my hat on one side or the other. Interesting also was the discussion of licensing. IEEPA has specific language that says you can regulate imports, and it does allow the administration to apply licensing. So there was a lot of discussion about what licensing actually is. How can that operate? Are there fees associated with that? Are there tariffs associated with licensing? And I know a lot of us in the trade that do this day in and day out were yelling, "You're talking about tariff rate quotas. You're talking about tariff rate quotas." But I don't think that that level of detail was understood by the justices or by either attorneys arguing this. It was an interesting discussion on licensing because licensing can be a limitation of trade. It can be a limitation in an absolute manner. You have licenses that are issued that limits the amount of products that can come in, and after that, no more products can come in. Or it can be tied to, this is a licensing, you can have a favorable duty rate and after that an unfavorable duty rate, or it can come in free and after that licensing volume is used up, it can actually incur a duty rate after that. So there was a lot of discussion on tariffs, duty rates, and fees, licensing fees, and how fees usually just cover the cost to the government to actually process that license or that trade remedy. Lots of discussion around that. So, what happens next? What happens next is a decision is expected in 1 to 3 months. Now, usually Supreme Court decisions take at least 3 months, sometimes 6 months to actually come out. Here we have the hearing and we get decisions in the spring and the summer. It's really interesting that a lot of pundits, a lot of legal experts are saying they expect this to be decided within a month. That could be due to administration pressure because they want to have this determined before we go into a new year. It could be that they want to get this tied up so they can take other actions. So, what are the results? What possibly could be the actions? Well, it could be, of course, decided that it's not unlawful and it will continue to go forward. That's what happened with the Section 301 duties. If you remember, there was a court case. They determined that they weren't going to overturn this. And we're still seeing those 301 tariffs. It could be that they could say this is not unlawful. They could turn it back to the lower court for a decision. They could say, well, we aren't going to decide. This needs to go back to the court based on this parameter or this decision. If it is decided that it's unlawful with a refund, it could be a full refund. And the Supreme Court could say all payment of IEEPA duties must be refunded automatically. And then it would be on the government to actually issue those refunds. And they could say, we're going to issue a refund, and they'll define a process that the trade must use and the government must use to actually refund those duties that were paid. It could be a full refund, and they could say, we're going to let we're going to let the government decide how they're going to issue this. And in that case, it's likely to be a protest. They could define what a protest is. There was a really interesting conversation. I believe it was Justice Comey Barrett who said, this is going to be a mess. If you have to file protests, how are you going to refund the duties? This is going to be a mess. And I just thought she has some insight into what actually are the processes for a protest because of the amount of duties that have been paid and the number of entries. If a protest has to be filed on every one and customs has to review that and take an action, this could take years to actually get the refunds. They could decide that it's unlawful, but they're not going to issue a refund. They could decide that it's unlawful going forward as of the decision date, that customs can't collect any further IEEPA duties, or it could say it's unlawful or there's an overreach or an overstep of the authorities, a misunderstanding of the authority, and it's going to stop after this date, giving the government time to make adjustments and the trade time to make adjustments. So what happens if they issue a refund? Is that it? IEEPA duties go away? What most people think will happen is the government will then step in and use that 338 or 122 authority, Section 128, 338 or Section 122 authorities to put additional duty in the same amounts that they've had on the imports while they take other actions. And we think those other actions are going to be Section 232 investigations. 232s have a defined process. They outline what the government must do to actually assess a 232 duty. Now, we've seen those massively sped up from what is a normal before this administration, but there is a process. They have to announce it. It has to be an investigation. The named party must look at these, or the named government entity must look at these, and then they make a decision, and then it's published, and then it can begin. So we think that will be used. Section 232 industry-specific duties will increase if IEEPA duties go away. Also an open question, what happens to the trade deals? If these trade deals are specifically mentioning IEEPA duties and they are based on the IEEPA duties, what's going to happen? Are those going to go away? Are those going to not take effect? We've seen some instances where House Ways and Means and Senate Finance have said we need to codify these trade deals because they could go away because they aren't in the actual free trade agreement process, which requires Congress to codify the agreement. So I think there's some concern about whether that's going to go forward. The other question is the executive order that assessed the IEEPA duties also eliminated de minimis. And there's some question in the trade as to whether if IEEPA is found unlawful, will that entire executive order be struck down, or will only the IEEPA duties be struck down? My guess on that is that de minimis is gone. It's dead and buried. We aren't going to get it back. We know in the big beautiful bill it does eliminate it in 2027, and I don't think the court is going to rule on that. And I think the executive order on that issue is going to stand. And if it doesn't, I think they'll issue another one or take another action to eliminate de minimis. So don't get your hopes up. If you're out there in the e-commerce world, I think de minimis is gone. But let's wait, see what the actual end game is for IEEPA, and we'll keep you updated. I hope everyone has a great weekend.